FLSA, which we'll get into in just a little bit, whether someone is properly paid on overtime, is another one that is regardless of the size of the company. And workers' comp, do you or do you not have workers' compensation insurance? If you don't, if you're self-insured, how is your employee notified of that? That's something that could come up with any size employer. At 15 is really the next big level, the big cutoff. So if you have 14 employees, don't hire that 15th one until you need the 16th or 17th, because it's a huge difference on what you're subject to. 15 kicks in Title VII, which is gender discrimination, race discrimination, religion, sexual harassment, not sexual orientation nationwide or in Texas, but some localities do it if you're a contractor for any reason. That is protected by some localities, but not by Texas and not by federal currently. At 20 is, that's okay, at 20 is age discrimination. 50 is the Family and Medical Leave Act. So 49 to 50, decide whether you want to have to give everyone up to 12 weeks off, unpaid, but hold the job, if they've worked the requisite number of hours per year. And then misclassifying employees, again, Fair Labor Standards Act, that's mostly goes to overtime and independent contractor issues. You do have the handout that has a lot of information on that, and we'll breeze through some of it here on independent contractor, but it is definitely a hot issue right now, and it's one that the current administration is looking at very closely. And it is one where there are conflicting laws, which we'll get to.
They have specifically hired additional auditors and investigators to go out and do that. So we're on notice.
Okay, and we can move on. All right, so what laws affect you? Again, it's specific to your state, somewhat specific to your industry. If you're in the healthcare industry, the background checks are even more, if you provide healthcare, the background checks are even more important, especially on any violence issues. If you work with children, background checks hugely important, things like that. So look at what your specific industry is. But generally, all the rest of employment law covers almost any industry. There's going to be some sort of employment law that will cover you. And we want to look at look at your, depending on the state and locality, what's protected. Well, and your size. It could be race, color, creed, national origin, ancestry, religion, marital status. Now, marital status in and of itself is not specifically protected, but what is protected is if you treat, let's say, a married female differently than you would treat a married male. There's really no reason for you to need to know if your employees are married. There's really no reason for you to need to know if they have kids. You need to know if they can get to work on time. You need to know if they can do the job. If you find out the rest of that just because you're working with them and they say, hey, I have to take off at 3 to go pick up my kid, will this job allow for me to do that? That's fine. But you don't need to ever ask that question. Gender and sex, which includes pregnancy, childbirth, other related medical conditions, disability, and we will briefly touch on this, but right now everyone is potentially disabled under the new amendments that came out last year to the Americans with Disabilities Act. So the battle is no longer whether people are disabled, it's whether they are qualified to do the job. Family leave or family care or leave status. Family responsibility law, there is no specific statute in Texas or federal that addresses that other than the FMLA if you have 50 or more. But I do expect there to be more coming. And states like California, if you have workers in California, you've got a lot more laws. But that's particularly one of them is just the family care. Parental Leave Act, which could be to attend. I mean, they literally, there's built in by statute that there's time off to be able to attend, kids' ballet recitals that are during the workday, things like that. And then sexual orientation, again, it is not protected federally currently. I do expect that to change, but currently it is not federally protected. It is not protected by any Texas law. It is by some localities. And as a general rule, it sort of kind of rolls into gender discrimination and probably falls under your sexual harassment policies anyway, the same type of behavior. So it's probably something that you want to effectively prohibit. Title VII, again, it's just also another thing to bear in mind is retaliation. I'm not going to read the whole definition out loud to you in the interest of time, but you have it right there. Retaliation is a big thing that the EEOC, which is the government agency, the administrative agency to which employees have to go first if they want to file a lawsuit. If you have 15 or more employees, they first have to go through the agency part with the EEOC, and retaliation is huge. Which is if they complain that they were discriminated against because of their age or their gender or something else, and you can flat out prove that's not true. But the immediate supervisor is just so angry at having been accused of this, because there's no way on earth they ever would have done this, that they just turn their back, and that person is just worker non grata after that, never gets any raise, never gets any good assignment. That's retaliation. Now the person does have an actionable claim. And the jury verdicts on retaliation are huge. There was one recently against Novartis, it was a class action, but it was $124 million jury verdict, right, in an employment dispute. That hardly ever happens. When it does, when there is something valid to it that gets to that point and convinces a jury, they're really mad. Okay? All right, National Labor Relations Act. Most of you, I would assume, do not have unions, probably because of the sizes, but you have to bear in mind that what the National Labor Relations Act considers a group that can organize 2 or more. 2 or more makes a group, okay? So if you have 2 employees, you potentially have organizing issues. There may not be a specific industry. You may not have blue-collar workers. There may not be a specific industry that fits that. Maybe you don't have electricians, or, you know, Starbucks right now is a big target of unions. And so their baristas, if I'm saying that correctly, are a big target of getting organized right now. Most of them are not, but they could be. But anything that's 2 or more could be what's considered concerted activity, and even if there is not a union, if employees engage in what the National Labor Relations Board, which governs that, deems to be concerted activity that's protected, and you retaliate against them for that, again with the retaliation, then you're in trouble even without a union. Okay, so if you have more than one person coming in to get together and you hear a phrase along the lines of, we've all been talking and we think that, okay, that's concerted activity. Which doesn't mean you have to give them everything you want, but you have to be able to show what you decide, why you decide it, and that it's not just because you're mad that they got together and talked outside of your presence. All right, other statutes. Again, ADA is disability, ADEA is age, which legally protected by age is 40. Okay, this is a little bit out of date now when you bear in mind the demographics of the current workforce. When it was passed, it made perfect sense. That you protect, you know, maybe the older third of the workforce. That's not what the word, that doesn't fit now, but it is still the same number. Okay, 40 and over is age protected. ERISA, you want to look at whether there are benefits, and if there's going to be an allegation that you got rid of somebody 6 months before they would have been entitled to retirement, or because they filed a lot of health claims and made your health insurance costs go up. Fair Labor Standards Act, we'll get to that in a little bit more, and FMLA is medical leave. And then Sarbanes-Oxley, to the extent that any of you have that, that's whistleblower, to the extent that you have to fill out any forms. Again, another form of retaliation, and pretty much anything that fits in the retaliation box, if it gets past a judge, past a summary judgment, and to a jury, juries get really mad at retaliation claims. Okay. Fair Labor Standards Act, the minimum wages increased in several increments, as I'm sure many of you already know. It is currently, as of July 24th of last year, $7.25 an hour. Federally and in Texas. Texas is never more generous than federal. Some states are. I think it's $8 an hour in California, and some others have different ones as well. But here, $7.24, and there have been several increases. So you may even have some employees who say, "But didn't that just go up?" Well, no. It was when it was passed to increase in several stages. We've hit the last round of that going up. It doesn't mean it won't again, but there would have to be new legislation passed to raise it again. Classification of employees. Who is exempt? First of all, who's an employee, who's a contractor? In the interest of time, we're going to, again, kind of go kind of quickly over that. But exemptions. Is your employee, if they're your employee, if you're past the contractor issue, they are your employee, are they entitled to overtime? And that's a huge budgetary issue. And a lot of people say, well, I pay them salary, so they're exempt. That's not the test. You may pay them salary and just have increased the amount of overtime that you owe them. By doing that. The test is, what are their job duties? What are they actually performing? It's not even by title. Some people will say, yeah, but they're a manager. Okay, it's a great title. Looks good on their resume. Are they performing the duties day to day that is actually exempt? So there are the different exemptions. You have these on your handout. You have a handout of the current exemptions and the short tests, which really this is the short version, even though you have 2 pages of it for that. And we can breeze through these. But the first is the professional. That can be a creative professional, which is usually a writer, advertising, marketing, or a learned professional. Learned professional is a degree, basically, or a degree or a practice that requires specific knowledge and training, such as accountant, doctor, nurse. Not all nurses are exempt. Some are, some are not. Depends on what they do. okay? But things like that would be a learning professional category that is usually exempt, but you gotta look at the job duties. The next is an executive. You have these duties or these components on your test. The next is administrative. Again, the minimum salary test for anyone to be considered exempt, to meet any of these exemptions, they have to be making at least $455 a week, or just by definition, no matter what kind of work they're performing, they get overtime. Okay. Now, with the current minimum wage, generally if you have someone performing these duties, you're not going to be able to get someone at less than that to perform these types of duties, but make sure at least of that. Computer employee is a tricky one, and that first part A you don't have on your handout because it's not officially part of the test. But if it's that guy who everyone says, call that guy because it's not working, then that guy that you call because it's not working and nobody can really explain what it does, and you ask him to write his own job description because you're not really sure, that's probably your computer professional. And they need to be making at least $27.63 an hour and be doing basically the thing that other people can't describe. In order to be exempt. You can also have outside sales, and we'll move on to the next one. Highly compensated. Some people say if I just pay them a high enough salary, that ought to get them out of overtime. Well, that starts at $100 grand a year. Okay? So that's the Department of Labor's version of highly compensated. It's got to be at least $100 grand a year. That cannot include any deferred money. So you can't say if you hit your goals, if whatever, then it'll get you to above 100. It's got to be $100 grand a year guaranteed if they're working for you the whole year. And that they're not doing any kind of manual work, basically nothing that would be considered or deemed blue collar. This also means not a lot of filing and data entry. Now, you're probably not paying someone $100 grand a year to do the filing and data entry, but even that, even not all office jobs are exempt. And customarily and regularly performs at least one of the other components. So those multi-part tests for the other ones, if you want someone to hit the salary test, the highly compensated test, and they have to be making $100 grand a year and hit at least one of those other categories. Okay, off the clock, you can't ever do it. You can't ever have somebody work off the clock. These are some examples, and you do have the printout of the PowerPoint, but these are some examples of verdicts. Juries hate this too. You got a lot more employees than employers on the juries. And if you're going to be hit really big, and some of these are settlements. I mean, some of these are the companies just decided it is cheaper to settle for $50 million than to go to a jury on this class action on this kind of issue. You can't ever have people work off the clock. So things to bear in mind on that. We can go to the next one. Is don't let your employees get a head start. Don't let them come in early just to make the day easier. Don't let them stay late just to finish up. They say, no, I clocked out. I just want to finish up. I want to clean up. If they are there, if they are working, they're on the clock. Okay. Don't let somebody work through their lunch. If they are working through their lunch, that's okay, but they get paid for that hour. If they're eating at their desk, and even if they're just there to answer the phone if it rings, they get paid for that hour. Do make sure that
apply to non-exempt positions?
This is non-exempt positions, okay. Right? Well, if it's an exempt person, you don't care how many hours they work,
yeah.
And that they probably don't know exactly how many hours they worked. But if it's a non-exempt position, doesn't fit any of those categories, and they could be entitled to overtime, they need to be paid for that hour for working through lunch. You want to emphasize the way to do that is, this is the category where really your best hourly employee is going to get you in trouble inadvertently. Because they're just going to want to work a little harder, do it a little better, not cost you more. I understand I'm only supposed to do 40 hours or 35, but I just want to do my work a little bit better. You need to explain to them that their time matters too. You want to compensate them for everything that they do, and you want them to stay. You don't want them to burn out. You would rather, instead of having an extra 5 hours a week, you'd rather have an extra year overall or 2 years overall of them in the position. And make sure that they take scheduled breaks and lunches. In Texas, that's not as important.